We've all heard the saying, power tends to corrupt, and absolute power corrupts absolutely. There are two major checks and balances to government: transparency and the First Amendment right to free speech. This court decorum policy places way too much discretion to one person, and that's Judge Tim O'Hare. And it discourages freedom of speech with the barrier of inconvenience. In this policy, the time limit is at the discretion of the judge. The speaker order is at the discretion of the judge. The judge can excuse a speaker, and I quote, for any other matter at the discretion of the judge. I am not okay with this, and neither should any member of this court be okay with this. This allows the suppression of voices under the guise of order. The public is not fooled by this. I've gotten lots of calls and emails. This court should not be fooled by this facade either. We just discussed in last court the unfortunate death of Mason Yancey. And as the jail continues to cost families their loved ones, the cost grows higher and higher for you taxpayers. I said this would happen, and yeah, here we are again for another large sum of money for outside counsel. So we've already spent $31,892 with just this one detention officer's case. If this court votes to approve this, this will be an additional $35,000 of taxpayer money spent. The cost of outside counsel is slowly climbing. In this case, just the Johnson case, to almost $500,000. And the court communication is not saying the price tag for this one detention officer's case will stop at $65,000. It's saying they can spend $65,000 of your hard-earned money before coming back and asking for more. And there will be more. Ego is going to cost this county a mint. And I'm going to show you where we are right now. Just in the Johnson case, it's one case. August 6, 2024, agenda item F1, amount $30,000 for one defendant. Agenda item F2, $30,000 for one defendant. November 12, 2024, $100,000 for an outside law firm to defend the county. Also on November 12, 2024, agenda items D2 through D9. The amount was $30,000 each for 8 defendants. But right now, we're at a total of $400,000. That's just for the Johnson case. We could have avoided spending this much money and more to come if we would have attempted mediation utilizing attorneys from our district attorney's civil division with regard to the outside attorney representing the county, not the outside attorneys representing the detention officers. This money is money that could have gone toward a settlement because we will end up losing. I wanted this agendized, as you are aware, just so we are transparent and so we don't fall in the same situation that Keller ISD did initially, where they were doing things behind closed doors. So I appreciate you giving us what you got so far. I've heard from many constituents, and I believe the only fair way for Keller ISD to move forward is to petition for a vote. That's my position. And petition seems to be the predominant mention of this education code, and constituents have questioned the transparency of this process. So I think to deny citizens the opportunity to decide the fate of their kids through election only furthers distrust and suspicion that agendas are at play without consideration of all families and all students. So